for the Legal Aid Agency. He's going to give us a bit of an overview about legal aid and what it is. Then we're going to hear from Richard Miller, who is head of legal aid for the Law Society. He's going to talk a bit about criminal legal aid. And then finally we're going to hear from Julie Bishop, who's the director of Law Centres Network, who's going to talk, I think, about civil and family legal aid and a bit about the Australian legal aid system, because she's worked in it for a long time. So yeah, Hugh Barrett.
Thank you very much. It's good to be here. We were delayed a little bit because of the bad weather. I think I'm probably the least popular person who's going to speak this afternoon. I think it's true because I work for the government, and the government, as you all will be aware, have been doing horrible things to legal aid. I'm here really to explain a bit about why, what has changed over the last few years, and what remains within the legal aid scope. So I'm going to say, first of all, talk about why, very briefly look at some international comparisons, and then particularly look at where the money goes. So, this graph is the key driver of current government policy on public services. The dark blue line is the money that the government spends. The lighter blue line is tax receipts. And as you can see, going back to the late 70s, there was a gap represented by the money the government had to borrow between the money that was spent and the money that was collected in taxes. For a couple of short periods, beginning in the 90s and at the turn of the millennium, actually the picture was the other way around. Government finances were in surplus. And then we tracked through to 2008 and the financial crisis, and you can see what happened there with bailing out the banks, with the collapse of the financial services market. Tax revenues basically stagnated, and the government had to find vast sums of money to keep the financial services sector afloat. What's happened since then, since 2009, is that government expenditure has been cut, and you can see the trajectory there. It's been coming down for the last 2 years, whereas tax revenues have been flat. The forward projection, and these numbers are produced by the Independent Office of Budget Responsibility, so these are not government statistics, these are independent economist statistics. They don't mean they're right, but they're not biased, show that by 2018-19, on current projections, the budget will be back in balance. But what that shows is that we've had to reduce gross public expenditure from something like 47% of GDP down to, like 38%, something like that. So that's a massive reduction in public expenditure as a result of the financial crisis. Second set of numbers, and we may have a little argument about this later on between ourselves, is this one, sorry, the next slide. This just shows really the spend within the Ministry of Justice. The Ministry of Justice spends money on prisons, courts and legal aid, and broadly this shows that over the last 4 years we reduced the spend on legal aid, criminal and civil, pretty well in line with the reductions in courts and prison costs. This one will cause the potential argument between Richard and I, so that'll be quite interesting later on for you maybe. This is per capita spend on legal aid. These are statistics produced by some Dutch researchers earlier this year, and they show that per capita of our population, England and Wales, we spend the highest amount per capita on legal aid. To be fair, there are some countries here which have different justice systems. They have inquisitorial systems, so they will spend more money on the judiciary than on advocates and lawyers preparing for cases. So it's not quite as stark as this graph appears. But there are some interesting statistics that aren't on this slide. If you look at other common law countries like Australia and Canada, their per capita spend is down in single figures, late single figures, early tens of pounds per capita. So for some reason, England and Wales, and indeed Scotland, spends significantly more per head on legal aid than other countries. This is a list of what's in scope, and perhaps I'll come back to this in a moment. Actually, I'll go on to where does the money go. Family is the biggest area of expenditure. These are last year's figures. Financial year ended at the end of March. Nearly £750 million spent on family legal aid. Increasingly, that's in one specific area, which is providing representation and advocacy for the families of children who local authorities want to take into care. That's the biggest single element of family. Second biggest area is Crown Court. Serious offences, those with over 6 months prison term, potentially as a result of being found guilty. Nearly £600 million spent on that. Magistrates' courts, high volume but relatively inexpensive cases, nearly 200 million. And then police station advice, where individuals who are arrested have the right to get a solicitor to attend with them at a police station. And then civil other, and I'll come back to the scope of that in just a minute, nowadays only £60 million, so it's very small apart from family. Just some basic facts, and Richard and Julie will probably, well, forgive me, I hope, for slightly oversimplifying this, but I've tried to identify here which of those categories of law are means tested and which of them are merits tested. Means testing does not apply in the police station, it's not merits tested. Literally, a multi-millionaire arrested by the police could have legal aid, a legal aid lawyer turn up and represent him or her in the police station. It's not merits tested, everybody gets it. Magistrates' courts is means tested, and there's a thing called the access to the interest of justice test that's applied as well. It basically says if you're liable to go to prison as a result of being found guilty in this offence, then you can get legal aid and it's means test. In the Crown Court, you pretty well automatically get legal aid from an interest of justice perspective, because potentially if you're found guilty, you go to prison for more than 6 months, but there's a means test in that area. In family, now, with the vast bulk of that being, say, in child care cases, that's not means tested or merits tested. So anybody whose family members are, or children are brought into, potentially brought into care, get legal aid. Mental health, which is a big area of expenditure, or a relatively big area of expenditure within that other civil area, which again, not means merits tested, and ditto asylum. Other civil categories are means and merits tested. And the merits test here means that you have to have basically a more than 50% chance of success in your case. So hopeless cases will not be funded, but cases which have a reasonable prospect of success will be funded. Where does the money go in terms of actual people who deliver the service? Solicitors, the organisation that Richard works for that represents solicitors, get nearly 2/3 of the money. Barristers, doing most of the advocacy in the Crown Court, and some advocacy in other parts of the system, get just about 1/4. Experts and others, forensic scientists, child psychologists, fingerprint experts, people who look at mobile phone records, etc., etc., they get just about 10% of the expenditure. Charities, the organisations that Julie's umbrella organisation is responsible for, law centres, CABs, they get about 5%. And then finally, just to complete this, we have a very, very small public defender service. Those are solicitors and barristers employed by my organisation to provide direct defence services to clients in 3 or 4 parts of the country. So that's where the money goes. Let's go back then just a bit about the scope. The big change that came in a year and a half ago was that many areas which were previously in the scope of civil legal aid were removed, most notably divorce, contact cases, unless there are allegations of or evidence of domestic violence involved, were removed from scope. And so what's left are what ministers and Parliament judge to be the most serious cases. So, for example, in debt cases where your house is possibly going to be repossessed, in mental health where you're being detained in a secure hospital, so where your life and liberty are at stake, then you get legal aid. But many other areas, for example, welfare benefits, which, if you can read the slide, I hope you can. It's now on appeals at point of law. There was more general advice available. So what ministers had to do 3 years ago was to make very difficult prioritisation decisions, decided that these areas of scope were those that they wished to retain, and other areas which were more discretionary and in their view less important are no longer in scope of legal aid. That's really all I wanted to say in terms of introduction to the schemes, but obviously later on I'm happy to take questions.
Okay, should we move on to Richard Miller?
Okay. For classes.
Yes. Right, well, thank you very much for that, Hugh. That introduction has been certainly quite helpful in setting a bit of context for what I want to say. He's right, I do disagree with him very strongly on the international comparisons point, and the reason is because if you look at the cost of the criminal justice system as a whole, recent evidence published a couple of weeks ago by the Council of Europe shows that we come about fourth from bottom out of the 47 members of the Council of Europe in how much we spend on the system. And by the way, we prosecute more people than anyone apart from Sweden. That's almost twice as many as France, half as many again as Germany, and yet the costs of the system overall are comparable. So when the government either reduces the number of people they prosecute or changes the system so that more spent on the judges and less on the legal aid lawyers, then perhaps we can have a discussion about us being the most expensive system in the world. But in the meantime, lies, damn lies and statistics, you've heard it time and time again, and you will no doubt continue to hear it. What I want to talk to you about today is what's been happening in the criminal legal aid sphere. And Hugh's introduction has given a very good overview as to where criminal legal aid is available at the moment. Now, in April 2013, the Ministry of Justice had been faced with a challenge from the Treasury to make a significant saving in its departmental budget, including from legal aid. It is one of the main areas of expenditure that the Ministry of Justice has, and it was inevitable with the Treasury imposing such cuts that legal aid was going to be put under pressure. So in order to meet that target, the Ministry came up with some very controversial proposals for the procurement of criminal defence services. Their initial proposals would have involved the abolition of a client's right to choose who their lawyer was. At the moment, anyone who is facing either arrest or prosecution can choose their lawyer, and that is considered a fundamental right in this country. The government's first scheme would have involved them having a lawyer imposed on them by the state, and that was highly controversial. And the other thing that the government wanted to do was to say that the contracts for doing the criminal defence work would be given to the firms that bid the lowest to do the work. Now, I don't know about you, but if I was facing a murder charge, I would not want to be represented by the person who promised to do it for the least money possible. This is something that, in our view, is too important for price to be the determining factor. Obviously, this is taxpayers' money, firms have to be accountable for it, and there has to be a careful eye kept on how much is spent on these cases. But the bottom line is, you have to pay enough to ensure that a decent quality service is provided. And certainly the Law Society's view was that price competitive tendering was not going to achieve that. And just to add to the fun, in order to make their budgetary savings, the Ministry's rule was that firms would have to bid at least 17.5% below the existing rates. Now, these rates were set in the early 1990s in cash terms. They have not changed in cash terms since before many of you in this room were born. That is what criminal defence lawyers have been faced with over the past 20 years. They have had efficiency saving after efficiency saving squeezed out of them, and in the last few years they've had actual cash cuts already several times in those rates. And the Law Society's position on this has been very clear throughout. Whatever you do to this market, however you change it, we do not see any way whatsoever that you can squeeze 17.5% out of it. It's struggling as it is fragile. But that was the proposition that the government came up with. And the other aspect of what they were proposing is, compared with 1,600 firms doing this work at the moment, their proposals would have left just 400 firms. So a lot of Law Society members, a lot of very good criminal lawyers were faced with being thrown on the scrap heap as a result of these changes. Now, the MOJ accepted that the market as it stands today would not be able to take those cuts. The market consists of very small firms. Solicitors' firms, generally speaking, consist of up to perhaps 20 or 30 people at most. There are very few larger than that. And they tend to serve just their local towns, or perhaps the local town and the next town. They are very locally based, they are micro businesses in economic terms, and they are not easily able to take shocks to the system in terms of their levels of income. The government's idea, though, was that if you had consolidation in this market, if these firms got together in much bigger entities, that you would then be able to deliver economies of scale, and this would enable the firms to absorb those fee cuts. So the government put this scheme together that in their view would bring firms together. And so what they said was, we want to offer contracts that are going to be large enough to be economically viable after we have taken 17.5% out of the fees. In order to do that, they had to offer contracts that instead of just covering the firm's local town, would cover whole counties, or sometimes even larger areas than that. And what they seem to have missed in doing that is that if you are going to have to provide services over a much larger geographical area, covering many more towns than you currently provide, well, you've got choices. You can develop new infrastructure to cover those other towns. You can travel to them. You can set up managerial arrangements with other firms to cover that work. But whichever way you do it, there's more cost there. It's not economies of scale, it's just scale, with a lot of extra cost attached to that scale. So that's going to require investment. That investment is going to have to be repaid out of something. You can't do all of that and then get by on 17.5% less than what you've got at the moment. So economically, from the profession's point of view, it just didn't add up. For all the power and the logic, though, in the arguments that the profession was coming up with, there is, at the heart of it, a fundamental anomaly, which I could never get any of them to admit, but I'm prepared to admit myself. And this is the idea of artificially limiting the number of firms that can operate in this field is an absolute no-go area for practitioners. They want a system where there is an absolute guarantee that any firm that meets the quality requirements should be entitled to do this work. However, if you speak to any criminal lawyer, one of the things that they will always say is that the biggest pressures they've been facing in recent years come, okay, partly from the fee freezes and cuts, but even more so from the drops in the volumes of work in recent years. Although we do have very high rates of prosecution compared with other countries, those rates have in fact been coming down quite significantly over the past 5 or 6 years, or in fact possibly even as much as 10 years. And so we have this anomaly that firms are complaining that there is this drop in the amount of work out there, that they are really struggling financially to cope with this reduced volume. But then as soon as you say, well, doesn't that mean therefore that you need fewer firms doing this work? The prospect of them not being one of the firms that gets the contract to do this work just looms large in their mind, and they resist it with all of their strength. So there is this real paradox at the heart of the profession's position in respect of how do you procure defence services. Those original proposals from the Ministry proved too controversial, and in September 2013 the Ministry issued a second plan. And under this plan, they would allow any firm that met the minimum standards to work for own clients. In other words, if the client specifically asked for that firm or went into their office to get the services, then they'd be able to do the work. But it would limit the number of firms that were allowed to do the duty solicitor work that Hugh talked about. So if you're arrested, you're entitled to a lawyer, but many people don't know a lawyer. And so there is this duty solicitor scheme that if you ask for the duty lawyer, there is a phone system that will call that lawyer, they will come out and represent you on the duty solicitor scheme. The proposal from the Ministry this time round was that all firms would be able to carry on doing work for their own clients, but that a limited number of firms would be given slots on the duty solicitor schemes, so that that work would be restricted to a much smaller number. To the profession, that was still a disaster. Own client work may be the mainstay of most of their businesses, but the duty solicitor scheme is where you get the new business to replace your clients who deprive you of an income stream, either by getting themselves banged up for a long time, as some of them inevitably do from time to time, or, heaven forbid, some of them even go straight, which is most unfair of them, and it's a real problem for these businesses. We really could do with a crime wave, that would make their lives far better. But the reality is, it's the duty solicitor work that replaces those clients who no longer come to your offices for whatever reason. So the view of most practitioners, rightly or wrongly, was that if they don't have the slots on the duty solicitor scheme, their firms will be dead in the water anyway. It's not a long-term viable solution. And so, as far as the profession was concerned, this concession that any firm would be able to do the own client work was no real concession at all. It still meant we would have massively fewer firms doing this work. So over the months since the MOJ announced it was going to proceed with this second scheme, there have been various discussions about how this policy decision can be converted into a realistic scheme that works on the ground. There is always a lot of devil in the detail with these things. And in fact, there have been two previous attempts to introduce price competitive tendering for criminal services in 2005 and in 2009. And on both occasions, the MOJ concluded in the end that it was too difficult, they weren't able to develop a workable scheme, and they abandoned it. I've come to the conclusion that probably every 4 or 5 years until I retire, I'm going to be going through this same battle. But we are where we are. And so there's all these technical issues, all these details to be resolved, and we are, I think, still some way from having resolved all of these issues. There are, in particular, major challenges for the legal aid agency as to how it's going to distinguish between bids from firms. So if you've got 1,600 firms at the moment and they're bidding for, say, 500 contracts, how is the legal aid agency going to decide which firms get those contracts? Now, there's quite a few problems around this question. The first is, when you start thinking about what the criteria might be, well, you want them to have experience of particular types of work, so you know that whatever case comes their way, they'll be capable of handling it. You'd like them to have experience throughout all the court system. The more you think about what are the things you want, the more you realise they're things you want from anyone who's doing this work. They are minimum criteria. They are not ways of distinguishing between bidders. And then when you come up with things that might distinguish between people, then often as not, they're things that every firm that's currently in the market would easily be able to meet. They may distinguish between an existing firm and a new firm that's coming into the market with no previous experience, but they're not going to distinguish between your current firms. So how you come up with a scheme that will actually distinguish between the firms is a major challenge. And the more minor those provisions get, the greater is the risk that actually a court would say they're not sufficiently relevant to the contract on offer, and therefore they're unlawful. And so the LAA could find itself faced with a judicial review, and not for the first time. Now, in order to decide how many of these duty solicitor contracts should be awarded, the MOJ commissioned a report from the consultants KPMG. And this report was published alongside the MOJ's decision that they were going to go ahead with this model. The report didn't make particularly comfortable reading for the Ministry because it highlighted numerous concerns and risks and flagged many areas where it said further analysis was needed. A number of specialist practitioner groups who represent criminal defence lawyers were very concerned about this report, and they felt that it should have been consulted on by the government when they were deciding how they were going to proceed with this system. And they brought a judicial review to challenge the government's decision to go ahead. And in the middle of September, judgment was given in favour of the groups, and so the Ministry had to hold a further 3-week consultation, which closed last week. In the course of those proceedings, it was disclosed that in August of last year, the Ministry had received another report. This one was from PA Consulting, another of the big consultancy firms, in which PA expressed serious doubts as to whether in this market economies of scale actually exist. And as I've already noted, the idea that there would be economies of scale was the fundamental reason that the Ministry put forward this proposal. That was how firms were supposed to be able to absorb the fee cuts. But now it turns out that PA Consulting had seriously questioned whether these economies actually existed. The PA report also said that after the fee cuts, only 1/4 of existing firms would still be profitable. So there is a serious potential impact there on the capacity of the criminal defence market to provide the services that are needed. 1/4 of firms would be financially profitable. And not only that, they said it's more likely to be the smaller firms rather than the larger ones that would actually survive. So there you have it. It's a very challenging situation. The government has to meet its statutory obligations, its obligations under the Human Rights Convention, to ensure that people accused of a crime have a fair trial. And that includes providing representation when that's needed. The Ministry of Justice has a budgetary limit that's been set by the Treasury. They can't just turn round to the Treasury and say, oh, sorry, we weren't able to do that, we've had to spend a bit more. The Treasury will not give them the extra money. The Legal Aid Agency has a real challenge in if it's going to have to distinguish between firms and limit the numbers who get the contracts, how is it actually going to achieve that? And practitioners have got to get their heads around this anomaly, that if their key problem is the drop in volumes, then how do they get to a situation where there's fewer people doing this work without also putting at risk the question whether they themselves will get a contract? How can you reduce the numbers while giving that sort of guarantee? So those are the challenges that the whole market is facing at the moment. There are distinct challenges in there for the Ministry and for the profession. And, well, we are in a very interesting point at the moment, waiting for the Ministry to decide where it goes next. But over the next 6 months, between us all, we're going to have to try and answer those challenges. Thank you.
Never held me back. Hi, let me know if you can hear me. Look, I'm sorry, but I'm not actually going to talk about family and civil legal aid. I sort of am, but for one reason or another, I'm going to talk much more about legal aid within the context of the justice system, and in particular the area that we deal with, which in the United States is called poverty law, although here in the UK we call it social welfare law. But tonight I'm going to talk about it in terms of poverty law because it's a stark title that really talks more about what it is that we're trying to do and why we're bothering to do it. But before I do that, I just want to start by saying something that is about Australia. I won't go on so much about legal aid in Australia, but I was in thinking about what I was going to say today. Early this morning, one of Australia's greatest leaders ever died. His name was Gough Whitlam. He was 98 years old. He was Prime Minister of Australia for less than 3 years, from 1972. Yet all day today I've been receiving messages from colleagues and friends about the impact of Gough Whitlam and his government on their lives. You know, this wasn't someone we actually knew. It was much more personal than the reaction to Margaret Whitlam's, his wife was Margaret Whitlam, Margaret Thatcher. It was a very personal response. And I've been thinking about why that is, and it is relevant to today because the reason for that is we're in a time of very mean-spirited, small ideas. We've got a reforming government here, but it's about punitive reforms. It's about blaming the victims, and this is what we see from the sort of legal aid work that we do. We're working with the people who suffer this punitive outrage. separated parents, it was very difficult. He recognised domestic violence as a crime and funded shelters for women. He brought in free universal health care, free tertiary education. He ended conscription, and you may not know Australia was fighting in the Vietnam War. He brought the troops home. And most startling of all, he and his Attorney General, or Secretary of State, the Chancellor, established a High Court of Australia. In the 1970s, Australia was still coming to England for High Court appeals. Can you believe that? So in that 3 years, they transformed the country and the legal and justice system. Indeed, the democratic apparatus of Australia was reformed in that time. And they did it. And those reforms, in spite of consecutive governments, and we've got our own small-minded government there now, have never turned back those reforms because they were good, they were enduring, and indeed they've been built on. But they did it because it was a government of big ideas, and not simply big ideas alone, but they had the courage to implement them. And right now, I think in many countries, but the UK included, is a time for big ideas. The justice system in the UK, and legal aid is just one part of that, actually needs complete reimagining. We're not talking here about money. Hugh's told you about the money. I'm not going to get involved in that argument about whether it's the most money or not. I mean, remember, Australia was a penal colony, so we, know about the impact of having large numbers of people prosecuted. It's not about the money, it's how you use that money. What is the most effective method of using it? But it's not only money alone. £1.5 billion is a huge budget. That alone should be sufficient so long as there are some other linked critical changes. So to think about legal aid and where legal aid ought to go, you need to think about it as but one tool in the kit of the justice system. And indeed, the justice system has to be remembered as a key component to the rule of law and therefore the democratic system itself. Legal aid is allowed to be isolated without people remembering it is actually the heart of this justice system. So tonight, I really want to talk much more about that. For us to have a really effective justice system in the UK, apart from reform to legal aids, there has to be law reform. For God's sake, it's the 21st century and there is still fault-based divorce system in this country. You have to go to court. That's why there's 750 million spent on family law. In most countries, it's a form-filling exercise. God knows why not. So that's about one example. We need much more simplified court procedures. There's a body of evidence to show if you're only spending £100 in the justice system, it can best be spent by simplifying court procedures. We need public legal education so people know what their rights are. And we absolutely need major prison and sentencing reform. Once you've got all that in place, then I think it's fair enough to start squabbling about how much money should be spent. But in particular, what's required is a very conscious response and understanding to the impact of people who cannot afford to pay for a lawyer, the impact of those unresolved legal problems on their lives. And that impact isn't like, they might go to prison for a while. The impact is, and I'm not diminishing, that prison isn't a difficult situation, but the impact on people's daily lives from what we call the law of everyday life, unresolved housing issues, unresolved debt problems, unresolved welfare benefit problems, unresolved family law problems impact on their mental health, on their housing. It breaks up relationships. It leads to debt and it leads people into poverty. So legal aid's not a standalone topic. It's in fact very much about people's lives, their ability to lead lives that are satisfying. I will mention later on legal aid systems, which I do think are worth looking at, and it's not the Australian system. But first of all, and taking us back to the topic of legal aid, is to talk about law centres. I don't know how many of you know about law centres, but basically they've been around for 40 years. They came out of the great student revolt of the 60s and 70s. They're essentially not-for-profit legal practices, but the aim of law centres is to use legal skills to address the underlying issues of poverty, hence the introduction. We do housing, benefits, immigration, employment. Benefits, immigration, employment, all gone out of scope. The most common legal problems no longer supported. So law centres, in fact, came into being when there was a much more extensive legal aid system, but they identified that it's not simply enough to have funding in place, you need expertise in the areas of law. And by and large, there wasn't a lot of expertise in the areas of law for poor people that we've just spoken about. However, that expertise was wiped away, more or less, on the 1st of April 1913, when the LASPO Act came into 2013. Oh, bloody hell. Yeah, a lot's happened in that time. And I'm not going to go on about that. You know, of course, there were protests, there were letters, we cried and stomped and did everything, but it didn't make a scrap of difference. It went through. So what are we doing now? You know, what is the way forward? We are where we are. And so what I would like to propose in terms of what the way forward is for legal aid, it's not necessarily the detail that Richard's spoken about or, you know, the argument about money that Hugh's spoken about, but it's in fact to rethink what is this system about? Why will taxpayers fund it? And I think it means that we need a two-tiered system. The first system is a universal system that in fact most people can have access to, rich or poor, because you don't have to be very poor to not be able to afford a lawyer. Indeed, you know, I always try and find some law centre lawyer to tell me something because I don't want to pay. But nevertheless, we need a universal system that most people can access so they don't resent paying for other people to have it. But that can be by telephone, it can be by the internet. It should be provided mostly by the private sector. I think it is the area for private sector, and it can be done in any number of ways. But we also need a very targeted and much smaller multidisciplinary legal service that's targeted to people who have complex needs and complex personal lives. These are the citizens who cost the most money from the public purse. They're the troubled families that the government talks about. These are people who in fact can't help themselves. They need a lot of direct assistance, and to use a telephone line or something else is simply a waste of money. They're people who, when I talk about a multidisciplinary legal service, by that I mean that the legal service shouldn't stand alone. It needs to be part of mental health teams. It needs to be closely linked in with financial counsellors. We need to form decent collaborations with counsellors, you know, with other people who can address these other issues. And we've actually got some terrific examples of this happening, and I'll mention Coventry because it's nearby. The Law Centre in Coventry is embedded in the troubled families. It's been evaluated, it's been shown to be very effective, because the other side of the coin is you can't try and solve a housing problem or a number of other issues when there's underlying legal problems, because they'll never be solved. They'll just keep bubbling up again. The other thing that probably doesn't interest you, but I'm saying this for Hugh's sake, is that this work has to be grant funded. Commissioning and contracting and everything is absolutely a waste of money, both for government and the people participating, because of the bureaucracy involved. And this isn't my idea. The National Audit Office also says this is best value for money. But importantly, as well as being multidisciplinary, these services need to do more than address individual assistance. It's important that individuals are helped, but one of the other wastes of money in the system at the moment is there's no learning. There's no funding to actually have a look at why are these problems arising, how can we prevent them in the future. And the way you do that is actually look at law reform. You do public legal education, you try and address the trends that are arising out of your casework. You go and talk to local authorities and you say to them, why are you always refusing to house 17-year-olds when there's a legal obligation to do it? If you don't change your practice, we will continue to take you to court. So it also needs to be more than a one-on-one service. And that does lead directly into the Australian model, which is, again, Hugh's right, it's very poorly funded, but out of that, well, no, I'm not going to suggest that's led to some good stuff, it's led to terrible stuff. But what they do have in legal aid in Australia, which is very good, is a salaried service. And that means that the Legal Aid Commission there actually employs solicitors who do some of the work like family law and other things. It's simply a cheaper way to do it. But they also fund very specialist services like Aboriginal legal aid, family violence legal services. What's law centres there are called community legal centres. They're funded, but there's also private providers. And together with that whole group of services, there's a very collaborative ethos. So people don't all try and do the same thing or sort of argue whether it's yours or there is argument, of course, but over other things. It's about trying to how best resolve the problems of the clients. I mean, the sort of problems there are is there's way too much bureaucracy, lawyers are paid far too little, etc., etc. Most of the legal aid spend goes on criminal. But in fact, Australia is not the model that I've put to you today if you really want to think about when you get into positions in the civil service or as policy makers or as judges or whatever. Ontario in Canada is the model that really is worth having a look at. It's very well funded. Across Canada, there is very little legal aid, but for whatever reason, Ontario has a very comprehensive scheme. It not only funds individual casework, but it very well funds preventative work. It has a whole centre to do public legal education, etc. But the final model, before I end, that I'll tell you about is Brazil. I've never been to Brazil. I'd love to go. I haven't, but I've heard the Brazilians talk at various international conferences. It's a very recent legal aid system. And the reason why it's interesting is because it forms part of their human rights framework. They have acknowledged that legal aid, for you to set up a Human Rights Act or even talk about human rights, there is no point unless you can protect and assert that right. A right is valueless unless you can make sure it's implemented. And for that reason, in Brazil, they created legal aid as part of their human rights framework. And that's why I think it's interesting and worth looking at, because it's not just seen as a little bit of something you do on the side. So in fact, legal aid, as we practice it, is in fact, and poverty law, as I'm talking about it tonight, is in fact about ensuring that each person can live in dignity in a truly democratic society. That's what it's about, and that's why we fight for it, and that's why we care about it. But just to end, I'm going to end with two little slogans from the 1970s to take you right back to Gough Whitlam. And that is, these two have heard me say this many times, and I'm going to say it because it's worth thinking about. And that is, poverty law came out of a whole lot of study into the requirements of what people in poverty need. But the key saying of that time that helps understand why it's a specialist area is that poor people are not simply people without the money. that means that if you give them a handful of money, their problems don't go away, because the multiplicity of issues that have led them into poverty are more than just money problems. That again leads straight back to the multidisciplinary service. But the last thing is with Gough Whitlam, his election campaign that led to their victory in 1972 was "It's Time." And so I'm saying to both of you and to anyone who happens to in the future be in a position of creating new policy, to remember it's time. It's time to reimagine this justice system, and it's time to ensure that every one of the citizens can benefit from it. Thank you.
Does anyone have any questions for all three of them, or anyone in particular?
So how are decisions made on like which services to cut? Because it seems like things like welfare maybe seem less essential, but would be better in terms of preventing lots of other people from using.
Okay. Elected ministers make those decisions. Politics is all about making difficult decisions, between various areas of expenditure, what level of funding for universities versus what level of funding for the justice system, and then within that, a Secretary of State would make a decision which would say, I think that welfare benefits investment in terms of legal aid is less important than investment in, let's say, youth custody system. Therefore, I will probably have to go to Parliament to get their agreement to this, and Parliament on occasions says we don't agree with what you've done. But essentially, it's ministers that are elected who make those decisions.
I think there's a real question around this about what is the evidence base on which they make these decisions. So when the civil legal aid cuts were going through Parliament, one of the things we did was we commissioned an academic from University College London to do a report for us, looking at the civil legal aid cuts that were being proposed and thinking about what would be the knock-on costs to the public purse elsewhere from making these cuts. And the conclusion he came to was that on a very conservative estimate, and assessing only those cuts that he felt comfortable about putting figures on, he felt that the additional costs to the public purse would be in the region of 60% of the reported savings from legal aid cuts. And if you are less conservative, or you take account of the more indirect impacts, then it was very easy to make the case that actually the cost of the cuts would be greater than the savings in terms of legal aid. To give one particular example that I think really goes to the heart of what's been wrong with this, they cut advice for people having problems with housing benefit, but they've retained advice for people who are facing possession proceedings. So in the past, someone would walk into a law centre with a housing benefit problem, the law centre advisor would pick up the phone, speak to the local authority, sort out the housing benefit problem. Now, the law centre has to tell that person, sorry, there's nothing we can do for you. They go away, the arrears mount up, possession proceedings are issued, they come back again, and there may or may not be something that can be done to help them save their house at that stage. Sometimes the problem will have got too bad and they will lose their home as a result. But even if you can save the home at that point, there has been all that additional public expense for no good reason whatsoever. It's an absolute balmy way of running a system, but that's what we've got.
I'm going to put forward the view that it is about politics, what they choose to cut. It's not about value for money. What was left in scope, in my opinion, is to do with what they had to leave in scope. This is in civil legal aid. It was to do with what European law ensured that they couldn't get rid of. And that's why it's a real patchwork of what's in and what's out, what could be challenged. That's one part. Part two, and I'm quoting Nick Hurd, who was in Community Ministers here, is that immigration and welfare benefits were both taken out of scope because their areas, number one, they want to control immigration, so why would they fund people to assert their immigration rights? And he said that in Parliament, I'm not, you know, and number two was welfare benefits. Similarly, they're reforming.
What was the name of the Australian politician who's
Gough Whitlam.
got?
Gough, G-O-U-G-H. Whitlam. Yeah. Google him.
He was most famous, well, in this country anyway,
Yeah.
most famous for being sacked by the Governor General
Well, I
under
didn't
very
exactly.
controversial circumstances.
Well, yes,
But that's
indeed.
yeah.
Indeed, but there's actually some quite funny stuff on YouTube, etc. at the moment of very 60s, 70s campaigning. This is completely off topic, but just because it amused me. One of his main campaign, icons or celebrities working with him was this woman called Little Patty, who, had a blonde, she was a young surfy chick who sang a really terrible song. And there's all these pictures of her now still with the same hairdo talking about himself. Have a look, she might even sing her one big hit.
On what the barristers in this context have been trying to do in their sections with regards to the problem.
Okay, so which problem are you alluding to? The criminal one that...
The criminal, yes.
Okay, criminal. A bit like on the solicitor's side, there are roughly 5,000 barristers who do criminal legal aid work, so it's not particularly practical to talk to individual barristers or their chambers. And so in the same way that the Law Society is the umbrella organisation that represents solicitors, there are two bodies really that represent barristers in this country. The Bar Council, which is almost exactly analogous to the Law Society, and there's also a specialist association called the Criminal Bar Association. The government, legal aid agency, have regular dialogue with those organisations, but I think it's fair to say that they're in the same sort of position that the Law Society and the solicitors are, which is they understand many of the sort of financial pressures, but the resolution to that is not clear, because ultimately, if money's taken out of the system, it comes out of individuals working in that system's pockets, and that's a difficult thing for anybody, whether they're lawyers or workers in any industry to accept. So that's the answer to your question from the sort of government and legal aid agency perspective.
Yeah, from the Law Society perspective, we tend to have regular meetings with a range of practitioner groups, which includes the representatives on the bar side as well as on the solicitor's side, because we do think it's important that we keep talking to each other about all the different aspects. There is, I think, a very different agenda here between us and the bar, because with the bar's current position, the issue facing them was fee cuts. And with the solicitors, it was the fee cuts, it was these new contracting arrangements that could see 3/4 of firms put out of business. It was a whole host of things there. So there were different strands, there were different agendas, but all of us had a common view that we really did not like what's being proposed, and we wanted to try and get changes, or better still, get the whole thing abolished if we could. There has been a series of days of action organised by the bar and by the practitioner groups. We always have to be fairly careful about things like that, because we are a trade association and not a trade union, which means that if we were to support any sort of action like that, the government could fine us 15 million quid, and we don't really want to face that. So we have to be very circumspect indeed about the extent to which we get involved in that sort of direct action. But we have regular dialogue, we talk to them a lot, we don't always see eye to eye either in terms of end goals or tactics, but we do speak regularly to make sure we understand what we're all doing.
I think law centres obviously have collaborative relationships with all the legal sector, and indeed we wouldn't survive without their support. Just this last 12 months, 25% of our income has come through in-kind and pro bono support, so they're very critical to the work we do. However, I do think the Bar Association ran a very clever campaign, and they did succeed in a way that we weren't able to succeed with the civil law. But one reason is simply, you know, the Prime Minister's brother is a leading barrister. They're well connected, they can talk to people, you know, so they did a variety of things, but my personal view is it's also to do with who they're able to have dinner with, who they're able to play golf with, in terms of the influence at the end of the day. That might be a cynical view, but, you know, there was the campaign, as Hugh knows, was very extensive against the cuts. There were over 5,000 responses to the consultation, lots of days of action, lots and lots and lots of things, but it didn't work. You know, there were a few things, but nothing in particular.
Yeah, well, it was kind of coming off of both of what you guys were saying, and to do the stuff that you mentioned about the 70s and about Brazil. Just, you said that you were at a trade union, you wasn't involved in that sort of kinds of action, but you also talked about sort of the political sort of backroom discussions and what have you. What I wanted to know was, what was your view on sort of like the political atmosphere back when you that underlined where you outlined the policy systems, where you said this was so good in Brazil, this is something that was new, but only just happened. Where did that come from? Is that similar to where it came from in Australia? Why are we not seeing that here? Where do you think that energy came from? Can we replicate it? I don't know.
That's a very good question indeed. I think part of it is we've been in a situation where basically in the 70s we were very successful in this country in persuading the government that it should be funding these things. And as a result, I think we became complacent. Because if you look in almost any other country in the world, funding from the government is just one element in a mix of things, including grant funding, including pro bono services, including levies on the profession in some cases. There's a whole range of different ways that they fund these things. And so, having everything funded by the government in this country, we've become complacent about it. We are very much more at the mercy of the government suddenly changing its approach to things, as has happened in the past 5 years. And so, I think in that sense, a lot of other countries are better able to withstand the changes in the government's approach. They're far better able to do that than we are. I think the other aspect is, if you look at some of these other countries, they're starting from a very low base. And so it's much easier in that situation to say, we haven't got this and we need it and this is why. Whereas we're starting from a high base, it's taken for granted. A good example of that is the family courts. What's happened is the government, I think, fell for its own propaganda, that having lawyers involved in family disputes means you stir up disputes where otherwise people would just get on and sort their differences out between them. Now, there's an awful lot of MPs who are divorced, and I would really love to ask some of them, did you feel that your lawyers stirred up disputes, or did you feel you needed your lawyer there to see you through this? Because I'm betting there's not a single MP who acted in person on their divorce. But they fell for the propaganda that it's the lawyers who stir up the dispute. And what they found, since they took the lawyers out of the family courts, is that clients are no longer going to mediation as they did when lawyers advised them that mediation was probably a good idea. They go straight to the court, they act as litigants in person, and whereas the vast majority of cases with lawyers settle well before you get to a final hearing, cases now are going to a final fight because the litigants in person don't have the advice and don't know what's a reasonable deal to settle for. So we are seeing now what it is that lawyers did, the way that they are the oil in the wheels of the machinery of justice. And it's now becoming visible in a way that it wasn't before, and it's because everyone took it for granted that it was so easy to say it's not important, we can cut it. So I think we may be coming to a point where the pendulum will start to swing the other way, simply because now those problems are emerging and we're suddenly realising, actually, yes, there is a good reason for having lawyers here, and perhaps we ought to do it.
Just to clarify, when talking of Australia, I was actually talking about that moment in time. The current Australian government is, I can barely look at the newspaper. If you want to see how not to treat asylum seekers, or, you know, it's across the board. So I'm not holding that up in any way. But I think and in terms of Brazil, it does come back. Brazil is a country of big ideas. We don't know a lot about it here in the UK, but in the mid-1980s, for whatever reason, the government decided that they wanted to make Brazil a leading nation within 20 years' time. And I remember reading that and thinking, oh yeah. But they've done it, and they've done it by having this 20-year plan, and they've looked around the world. So in the case of legal aid, Richard and Hugh will both know people from legal aid in Brazil and legal aid scholars. They came to all the conferences, they talked to people, they thought about it, they examined systems, and on the basis of that, they built their system. And that's the reason why I say it's worth looking at, because they've genuinely tried to learn the lessons from others. But they don't have much money. Richard's absolutely right. It's a very poorly funded system, but the way it's constructed will allow it to grow and be worthwhile. But if you're talking about political engagement, I think you just have to look at what happened in the Scottish referendum to know that people want to be engaged if there's, whatever way you think about it. I think the most interesting lesson of the Scottish referendum was up to 80% of people were voting. So if it's something that means something to people, they will get engaged. What we're seeing now is that politicians can do all sorts of things because people can't relate to it. And I don't think UKIP will solve that. I think there's lots of lessons, and I'd probably prefer to talk about that rather than
Yes, I've no idea what UKIP's policy on legal aid is.
Oh, well, actually, I do know.
Oh, right.
They are one of the two political parties. That I hate to say this, but they have said that they are going to increase legal aid.
Oh,
right. Okay, everyone vote UKIP.
Let me be, as a civil servant, I've got to be completely impartial. The other party that said that is Plaid Cymru, but there aren't many Plaid Cymru candidates, I suspect, in this part of the world.
Excellent.
But anyway.
Excellent. Okay,
I
everything.
have two questions.
Yeah.
First one, what alternatives is the government going to implement to narrow the gap that they've created for access to justice?
I think the answer to that would be we don't see there is an issue with access to justice in this country. Now that would be the government's position. That appears also to be the position of the main opposition parties, because they have said, certainly the Labour Party has said, they will not be changing the current policies largely. There are one or two areas where I think they would. For example, there's a proposed residence test for civil legal aid, which I think the Labour Party would probably reverse. But at the moment, the government's position would be there isn't an access to justice gap, therefore there's no need to make any changes to the policies that are in place.
Probably won't surprise you to learn the Law Society strongly disagrees with that view.
Yeah.
What we're doing at the moment, we're doing a strand of work that we're calling an Access to Justice campaign. It's not a campaign as in go out and wave placards. It's a series of pieces of work, one to engage with the public about this, one to look at possible policy solutions, and also to educate the profession as well. One of the problems that lawyers have is however you spin it and however you argue it, they've priced themselves out of the market in a lot of cases. Solicitors traditionally will offer a full casework service or nothing. And for a lot of people, even before all of these cuts, they didn't qualify for legal aid, no way in a million years that they'd be able to afford the full casework service. So lawyers, I think, need to get their heads around the idea of finding different ways of offering services, finding cheaper services to offer, finding ways of offering at least part of what clients want. Because I think it's in the interest of the public, because it means that more people would get help. And I think it's in the interest of the lawyers as well, because if you've got a choice between offering a service that's going to cost £5,000 and the client gives you nothing, or you offer a service that's going to cost £500 and the client buys it, well, that's £500 your business has got that it wouldn't otherwise have had. So I think there is a lot that the profession needs to learn about what it can do, particularly with new technology, in improving access to justice. But having said all that, we have absolutely no doubt that whatever the profession does, there are certain elements here that can only be solved by the government changing its position. And we will be pressing very hard on the government, whichever party forms it, to do just that.
And just to build on that, you know, this is a democracy. There's an election coming up in May next year. Those of you who are voters, this is an opportunity for you to have an engagement with your local political candidates and to express your views, because that's actually what will change the view of government, is if they believe that the majority or a sizable proportion of the electorate feels strongly about the issue. And it goes back to Julie's point about the Scottish referendum. If people feel strongly about things, then things change. And at the moment, most politicians I speak to say legal aid is not on the minds of the vast majority of the public. But you can do something about it.
That's true. However, there has been quite a bit of polling and things done. And so if you ask someone, what's the big issue for the coming election, unfortunately they may say immigration. But if you dig down further, in fact, it's a couple of years old now, but the Legal Action Group did an Ipsos Mori poll and found that there's over 80% support for publicly funded legal aid. And the areas where it's most supported is housing, and the second is employment. And in fact, employment's gone out of scope of legal aid. So there is actually public support, but it's the sort of thing that it's what you call a safety net issue. People only care about it when they need it. It's not something that is available that people think they can have all the time. And that's one of the reasons why I think we need to have a universal service that anyone can access. A bit like in the Netherlands, they have these legal counters where anyone can go in and get a bit of help. If you have that, then that also creates the conditions for having a more intense service for the people who really need it. But in terms of access to justice, I agree with Hugh that the government doesn't acknowledge there's a problem. However, although if we take employment as an example, at the moment there are huge problems with people on 0-hour contracts. People who I was just in a meeting before who are being employed, for a few weeks and then they're not being paid and they're being sacked and they've got no mechanism for getting redress to that. They can't. There's a free telephone line, but it can't help with it. If people are able to spend £1,200 to go to an employment tribunal, even though they may not be represented, the other side will be represented, so there's no equality of arms. So there is a very significant access to justice problem at the moment in the UK. The question is, how do you make it an issue that politicians actually want to do something about? We've obviously talked to all the parties, as has Richard, and they're sort of interested, but the big ticket items are just so all-encompassing. What I'm hoping for is something that they'll agree to just do once they're in government, but it's not an announceable, it's not something that they'll have in their brochures, but maybe you can capture them and they'll do something afterwards. But in fact, there's 25% more going to be cut from MOJ, is that correct? So
Well, that's the projections.
yeah, so chances are more is actually going to be cut, not less. Anyhow,
Yes.
just,
Interesting bit of context.
yeah.
Under the previous Labour government at least, the legal aid budget, the total annual legal aid budget, was about 1/3 of the annual increase in the National Health Service budget. That's how much we're talking about for legal aid. It is margin of error stuff in public expenditure. And one more thought for you as well. You see a lot of people defending the NHS, fighting hard to say these services are vital, they must be made available to everyone. When was the last time you saw someone push back against that and say, oh, you're just defending those fat cat doctors, they're all wealthy, why don't they do it for free? Now look at legal aid, and that is the response every time. Why is the NHS about patients, but legal aid is about lawyers? Legal aid is about the clients. The lawyers will be fine. You could abolish legal aid overnight and the lawyers will be fine. They'll either find other law to do or they'll find another career using their skills elsewhere. Legal aid is all about the clients.